Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is William Mahan, who I'm just going to call Bill. And Bill is an attorney here in San Jose, California. He is of counsel to Gates, Eisenhart, Dawson. He's been practicing law about 37 years. Has a master's degree in taxation from Goldgate University and his law degree from Santa Clara University. And Bill's practice focuses on estate planning and probate and business planning for small businesses. Today, which is October 25th of 2016, Bill and I are going to be talking about tax and financial considerations of title. And as we get started in this area, I want to caution our viewers to seek legal advice. Some of you may be watching from other states and so forth. Bill is a California attorney. I'm a California CPA, so we're talking about California law. And there are some differences, particularly related to community property. There's even different flavors of community property in different states that have community property. So definitely do get local advice, but this can be the beginning place for you to get some information to continue the conversation. Bill, thanks for joining me today.
My pleasure.
Okay, Bill, what are some different ways that you can hold the title to property? And when we talk about property, a lot of people think real estate, but there are other types of property. There's brokerage accounts and
right.
savings accounts, what have you.
Right. Well, separate property, most people think that's for single people, but you can have separate property even if you're married.
Uh-huh.
So you could hold title as a single person as sole and separate property, or you could hold title as a married person as sole and separate property. In California, we have, as you mentioned, community property, which is a special type of marital estate. There's also tenants in common,
Mm-hmm.
which is where people jointly own property, but they actually, each owner owns the whole property. It's kind of a strange concept, but everybody owns the whole thing in some percentage.
Yeah,
But
they own a share of the whole thing. So yeah.
Well, they have the right to use and
Okay.
benefit from the property as if they own the whole property. So
Okay.
that's kind of a conflict in a way. But
Yeah.
tenants in common is a very complex ownership, but it's fairly common.
Huh?
There's also something called community property with right of survivorship, which is similar to joint tenancy, except that it's intended for married people, or nowadays married people, meaning heterosexual couples, same-sex couples, or even qualified domestic partners can have community property in California.
Mm-hmm.
And then there are different types of entity type of ownership. For example, you could transfer your property to a to a trust and own it as trustee, or in a bank account you might have what's called a payable on death account, or maybe a Totten trust account where you have title held in your name but with a beneficiary designated. And certainly there are also entities that own property, like limited liability companies and partnerships, which you can own the entity and then they can own the property.
Okay. Okay. So this may seem a little bit like old news, but I think I'm going to mention it anyway because we're still talking about something that's happened in the last few years. And that has to do with the business with same-sex couples.
Right.
And so the Supreme Court, we've got this Obergefell, and I don't know if I'm pronouncing it right or not, but anyway, the Windsor decision. So basically, now we have marriage across the board in our country for same-sex couples and so forth. What's some of the impact on it from a community property standpoint?
Well, in California, actually, it's been around for a longer time. So in California, we had what originally the first concept that got, into the statutory system was the registered domestic partners. Domestic partners, where you weren't actually legally married, but you could register with the state as domestic partners, and then you could have community property as far as you could decide whether you wanted that, but you could have that. With the federal law changing, it made actually a lot of changes because California law, applied in California and applied to California retirement systems and to California ownership of real estate. But by changing the federal law, it changed a lot of things having to do with all kinds of retirement benefits, including the ones that are covered by ERISA. It also changed whether or not a person qualifies for a marital deduction in an estate tax situation. So it's a whole much bigger overlay of the status of married people to a bigger community of people.
Okay. So how do some people try to bypass probate just using the title for their property?
Well, I've mentioned a couple of types of ownership that might do that. One is joint tenancy with right of survivorship, and the other community property with right of survivorship. And so what you're attempting to do there, or what you are doing, is by how you hold title, when one of the owners dies, the surviving, the right of survivorship people, surviving joint tenants or the surviving spouse, will take the property without going through probate by simply recording an affidavit of death, and then have ownership of the property as the surviving person. It's a simple method, but it's actually not good estate planning if you're thinking of doing it as estate planning, because it has lots of pitfalls.
Right, so the joint tenancy that we were talking about, in many cases, but if you have community property, we have something that some people call a double step up. You adjust the whole basis for the property to the value of death.
Right. One of the benefits, one of the benefits of community property with right of survivorship is it eliminated or avoided the problem where you would have a husband and wife, you would have a husband and wife own property as joint tenants with right of survivorship, which was quite common. But from a tax standpoint, when one of them would die and the other one would become the surviving owner, the estate tax, the basis of the property when a person dies, the income tax basis is increased to the fair market value at date of death. But there was a glitch in that where if you just terminated a joint tenancy, you didn't get the stepped up basis on the first death, only on the second death. So you ended up with half a stepped up basis.
Yeah, you get half of the stepped up basis.
Right.
Instead.
And so that would be a mistake. It's not very common to have it anymore, particularly with community property. And the other thing is, even if you own the property as joint tenants, as husband and wife, you don't have to terminate the joint tenancy as the way you transfer ownership. And you can still get the stepped up basis if you do it correctly.
Okay. And there are other types of assets that have beneficiary designations that don't go through probate, isn't that right?
Right. Again, you can have trust accounts. They're called different things, but Totten Trust would be a type of an account. Retirement accounts tend to have beneficiary designations, annuities, life insurance contracts. So there's a lot of assets that don't go through probate because of the way that the beneficiaries receive the property after the person dies.
So in those cases, we have a contractual arrangement with a beneficiary that's named, and so it just gets paid to those people.
Right.
What do you think the biggest mistake that people make when they're thinking about title for their properties?
Well, there's a lot of mistakes that people make. When people try to do their own titling, they try to do their own conveying, and I see a lot of that, even completely handwritten deeds. Conveyancing is actually sort of an art form. There's a lot of right ways to say things and a lot of wrong ways to say things, and so if you don't say it correctly, you can actually make quite a hash out of your title. I saw a deed recently where a married woman put her name on a deed as an unmarried woman. It created quite a lot of confusion and issues, and it was just, she didn't do it herself. It was done by whoever prepared the deed, but it was a mistake. So it's important, I think, to think of conveyancing as a serious matter and getting it correct. The other thing that happens is sometimes people will set up a trust or a partnership or a corporation and something they want to transfer title to, and then they never actually do that. They don't do the conveyancing. So they set up the entity. Again, recent case, I had a husband and wife who did a trust. They both died. The children went to sell the property from the trust, and they didn't ever put the property in the trust.
Oh.
So all of that planning was for naught, and they were back in probate court because the conveyancing never occurred.
Yeah. Now, there was another thing I think that you and I talked about before, and that is, like these joint tenancy arrangements and so forth, people, the plan doesn't work according to what they thought that it was going to be. People die in a different order and stuff, and that sort of messes things up.
Right. Like I said, to me, it's not really planning. I call it hoping. when you set up a joint ownership in order to avoid probate, in particular, because people don't always die in the correct order, and if you add your children to your title and one of them dies before you do, you haven't accomplished anything, and their children certainly aren't going to get anything from that parent because they died first and you ended up owning the property. The other kinds of problems that happen that people don't think about is if you add people to the title to your property and they have a divorce or a bankruptcy or a liability issue, that property is now part of their asset list as well, and now your house is on their asset list, and that can be a really significant problem. Other things that lawyers see that other people don't think about is that sometimes people don't get along for their whole life, and then they'll have a falling out, and they'll end up in court fighting over having people added to their title when it was done for avoidance of probate, but now they look like they're owners of the property, which perhaps they would be. Another significant problem that can happen in particular with joint tenancy is something called severance, where there's actually a deed that exists that's designed to sever a joint tenancy. And the other joint tenants may not even know the deed was signed because recording that deed is considered to be notice. And so spouses can do that to one another and eliminate joint tenancy. Parents and children can do it. If you add your children as a joint tenant and you have that falling out and they record a deed severing the joint tenancy, they now own part of your property. And what you become then is tenants in common, and which I mentioned before, where you jointly own the property, and that may not have been what you intended at all if you intended it to pass at death.
Right. And all these things, then suddenly this person has the ability to transfer the property, their share of the property themselves without your consent.
Well, they could. It's sometimes difficult to transfer a portion of a property, but I mean, it's certainly something that's probably going to end up in litigation. And
if you create a mess.
Right.
The other thing is that there are gift tax consequences when you make these joint tenancies.
Well, there could be. There's always an issue that what you did was actually transfer an interest in the property, not just add somebody's name to your title.
Yeah.
And so the question is, was that a gift of some sort or not? And you get into some fairly complex rules and issues to determine whether that was. If in fact, like I said, if the child severed the joint tenancy and became a tenant in common, I think at that point something's happened because now they own part of your property. So.
Right. Okay. How can a husband and a wife, or husband and husband, or whatever, wife and wife now, accidentally transmute separate property to community property, and what are the consequences?
Well, yes, as I mentioned before, people often bring assets into a marriage, and the assets they bring into a marriage, many people may think it immediately becomes community property, but it doesn't. So when you're first married, the property you brought in, whether it's a house or a bank account, is separate property. Your separate property. The property that's community is either property that the spouses agree to make community, or, for example, earned income is usually community property. So if you open a bank account, husband and wife, and put your paychecks into it, that's community property. If you take the same account that you had your separate funds in before you were married and you start adding paychecks to it, that's accidentally creating community property. Because what happens then is it commingles the funds, and there's something called tracing where you can try to unravel that, but it's difficult, and if you can't unravel it, then there's a presumption that the entire account is community property and half belongs to each spouse. Okay. So it's pretty easy actually to accidentally create community property.
And then, so what's the consequence of that when make a community property?
Well, there's actually three different places, significant areas where community property becomes important. One is when people get divorced.
Right.
And then you divide the community and you keep your separate. And so the more community you have, the more you're dividing. So if you accidentally transmute your separate property to community property, you're basically giving half of it away if you get divorced. The other time it matters is when you die, which again, the determination needs to be made what's community and what's separate, because who actually inherits your separate property, it's not exactly the same plan of distribution as it would be with community property. And that is based on the probate law, not your will. Your will, you can give away your separate property and your community property. But the point is that it matters when you die whether it's separate or community, and how large the estate is, also for estate tax purposes. And then the other place that matters significantly is when creditors are trying to collect money from you and making a claim, and they can reach community property.
All of it?
Yeah, if one spouse does something and there's a claim, the other spouse's community property is probably going to be subject to that. But separate property is much more protected from that. There are rules that are pretty extensive about that as well, but your separate property is less accessible by creditors. So
yeah,
it matters.
Okay. Let's see here. So maybe you can talk about what are some title considerations for entities like trusts and family partnerships?
Well, I'm not. Yeah, try me again. What are you asking me?
Okay. So when you make a partnership or a trust, what sort of problems do we have? Specific, I guess we can say, and it relates to making sure that the title is clear to the partnership and to the. In other words, does it say in the title, what you're doing related to this property?
Well, I guess I mentioned before that when you create a trust or a partnership or an LLC, you need to, if you're going to put real estate in it or other property into it, you need to actually title the assets in the name of the limited liability company or partnership or whatever. And if you don't do that, then it's unclear whether or not, for example, in a limited liability company, part of what you're trying to get is liability protection. Mm-hmm. If you leave your real estate out of the LLC and in your name alone, and you're subject to a lawsuit, your asset may, if it's not in the limited liability company, let's say it was an apartment building, and something happened at the apartment building. Well, if the asset is in the LLC, then the exposure you have is limited to the assets in the LLC, like the apartment building. Your personal assets, your own home, your own other assets like investments are not exposed to that. But if you never put the property into the LLC and it's still in your name, you didn't protect it. You didn't, in other words, all your assets are potentially subject to that liability because you owned it.
Good.
Did I answer that one?
I think that helps. All right, let's talk a little bit about property tax considerations of a change of title. What are some things to think about related to that?
This is another pretty complicated area. Anytime, we had years ago in California something called Proposition 13, where the people of California voted and said if there's no change of ownership, they don't think the property should be reassessed. And so it became very important to know what a change of ownership is. Subsequently, we had other propositions and other laws passed that say that a parent-to-child transfer, for example, is not a change of ownership, specifically excluding that from the rules of reassessment, so that you could transfer property to your children and they didn't have to have a new property tax
basis,
liability.
Or
And so, and so these things are all very highly scrutinized as well, because obviously, the taxing authorities want to be able to reassess property if they can, because the values go up over time. And that's how they pay for roads and schools and all kinds of different things, and so they want to be able to collect the tax. So when you record anything in just any county in California, that's one of the things that's going to be scrutinized. Is this a change of ownership? And you have to explain on the forms you file, if you don't think it is, why not? So a transfer from spouse to spouse is exempt from change of ownership reassessment most of the time. A transfer from parent to children or from children to parents most of the time, almost all the time. A transfer from brother to sister is not. And so you can have a transaction that you think is exempt because mom left the property to two children, but then the children decided, well, you take this one and I'll take something else. And that can create issues of whether or not that was a parent-to-child transfer or a brother-to-sister transfer. So all kinds of things like that. You have to be very, very, careful and pay a lot of attention to these rules to avoid having a reassessment when property transfers. And it also can happen when people transfer property to entities. If that isn't done in the right sequence, you can end up with a change of ownership that is reassessable.
Right.
And the other type of tax that can come into play there is transfer tax, which is what's charged when deeds are recorded, and those rules are quite complex.
Right. So it's probably not a good idea for people to just make a quick claim deed and think that they've taken care of this issue.
No, sometimes you can't avoid it. It depends on the reality of the situation is whatever it is. So you may not avoid things like a reassessment, but at least you would know. I would like to know before I did a transaction if that was going to happen.
Right. So really, you should get advice when you're doing these transfers, and there are forms, there are exemption forms that need to be filed with the county assessor, so that they know this is an exempt transfer.
Right. Like I said, anytime something gets recorded, it's going to trigger a look from the assessor's office, and people will start getting letters and inquiry and that kind of thing.
So from this conversation, the titles of things are pretty important, and I know that there are like some boiler room, I guess we call them operations, of different people that generate estate planning documents, and maybe they don't look quite so carefully at some of these things. It seems to me that an attorney would want to see the deed for the properties.
Absolutely.
Yeah. They would want to see account statements for the brokerage accounts and so forth, see the life insurance policies that a person has.
Most of the time, if you get one of these mass-produced estate plans, they don't get involved in the titling of assets. What they do is they give you an instruction sheet telling you need to do these things, and have at it. They aren't going to do it for you, and that's partly because these type of mills are not charging as much money, and they're not really probably having a one-on-one attorney-client process most of the way through, and so they prepare the documents and they give you a lot of information about what you need to do, and then they give it to you. And
so then you're on your own. And that means, though, that if nobody follows through, that you don't get the results that you're hoping for from these documents.
Right, like the family I was telling you about that did the trust and didn't transfer the home, and they got that trust off the internet.
Oh, how nice! Yeah. So, so it's dangerous to do this do-it-yourself approach. And a lot of times, of course, money may be tight and so forth, but it's what I guess what they call being penny wise and pound foolish, I guess.
Well, another thing is a lot of things, when you're talking about titling, a lot of things that people create can be recorded. And so they've become part of the chain of title, but that doesn't necessarily mean that anybody actually read them to see if they're doing what you think they're doing.
That's scary.
Well, that's not the recorder's job. They need to see if it's recordable. If they see something glaringly wrong, then they'll kick it back. But if you're just messing up the legal description or the way that you're establishing the title or who you're adding, how you're doing it, it's not their job to tell you that. And so an awful lot of things get recorded that are really creating problems.
Okay. So. Well, we're getting close to finishing up here. So maybe you can throw out some final thoughts for people here related to this area of tax and financial considerations of title.
Well, I just think it's important, again, to get good advice. You have, people live in different places, have different laws. We talked a lot about community property today. But there are other places. When I'm dealing with clients, I often have clients who have things like real estate in different places, different states. I don't try to deal with conveying title in different countries, but in different parts of the United States, Hawaii to Florida, every state is different. Mm-hmm. And it's actually a bit of, again, a bit of an art to learn how to do that. With the age of computers, we can now go online and go to the recorder's office in just about every county in the United States and find out how they want things done and get the forms they want done. But here we are in California, we have our own set of laws and recording rules. And in Nevada, which is, a couple hours away, an hour away if you're in an airplane, the rules are completely different. I mean, the recorder's office works in a similar way, but the forms they require and the things they want people to sign and the information they want is quite different. So if you're going to try to do it yourself, you have to do a lot of research. If you're going to, probably better to have people that are informed on how to do that help you do it.
Yeah. Well, I want to thank you for joining me today.
My pleasure.
So folks, I think as you gather, this is actually a pretty complex area. And anyway, but we just wanted to, again, give you an introduction. And so again, you'll get your own legal counsel related to this. We'll see you next time on Financial Insider Weekly.